And who are your ideal clients? I know it's a broad question, but like,
Well, I always found that the clients that follow my advice and always respond to my communications tend to do the best, even if the case isn't that good. Like if you have a really good client that's just on the ball, then you could have a pretty fair resolution. But when the clients don't cooperate, don't call me back, try to hide things from me, that's when the case usually doesn't go good, and the client's not really doing themselves a favor either.
And so in general, like how can someone find you? Are you on social media? Are you on your website?
I have a website, and I think that if you search, a local personal injury attorney on Google, you might find me if you scroll down far enough. But I am really trying to grow my practice through word of mouth and referrals, because I found that most personal injury cases are from referrals. That's how most attorneys get cases. And I feel like if somebody tells you that they know a personal injury attorney who's good, then they're more likely to go with that referral than find somebody like on a Google search.
100%. In fact, I think 99% of my business is all referral based. In fact, I know I'm probably you sent me a client because ultimately it's who you know, and I think there has to be comfort level. And so James, I really appreciate you basically being, sharing what was coming out for you. Is there anything I did not cover that you want addressed, or and I definitely want us to do another series at some point. Maybe we could talk about more complex PI issues, because then I kind of picked this topic for you because we were talking about it.
Well, one thing I wanted to say, and this goes to the practitioners out there too, is a lot of personal injury attorneys will treat like a product liability case or a premises liability case like an auto accident case. Like they might set up the client for a lot of treatment on a lien basis and have the bills really rack up, and then think that the case is going to settle right away, when then just to find out there's a lot more complications and down the line. And you just have to be ready for the long haul in these sorts of cases, because like in an auto accident case, you're basically doing a claim against the person that hit you.
Mm-hmm.
But in a premises liability case, there's usually multiple defendants that have control over the alleged defect. And then a lot of the game is trying to find out who those people are. And then I do a lot of product liability cases where, you think that the only defendant is the person that you bought the product from, but there's also the manufacturer of the product and anybody along the line of distribution that you can bring the claim against.
So your standard practice is to obviously locate all the defendants and hopefully name them. And I'm sure that process can probably take a while too, right? Because sometimes there are people you just don't know.
Right. And so that's why you really have to be careful with whether you authorize treatment on a lien for the product liability cases and premises, because like you're not going to know who these people are sometimes until you file a lawsuit, and that could be years down the line. And just sometimes you find out that these companies went out of business a long time ago, or they're located in different countries or things like that. So basically what I mean is, like, sometimes clients treat on what's called a lien basis, which is basically like where. That
was my question. I was going to ask you, what, you mentioned it. I'd love for you to explain. What does that mean?
Yeah. So this is mostly seen in auto accident cases where liability is clear. The clients will treat with doctors outside of insurance. The doctors will send me a bill, and then that bill is paid like usually through the settlement. But clients don't understand that if the case doesn't settle or the settlement's too low, then they still owe those medical bills.
Okay.
And so my point that I was trying to make earlier is with the product and premises cases, you have to be careful with this lien treatment, because if some of the defendants like went out of business a long time ago, and then the client owes all this money in medical bills, and you find out that these are not viable defendants years from then, like, you could be in trouble.
So, wow, that must be a wake up call for clients. And they're like, "What do you mean I owe money for what? I didn't do anything."
Yeah. I usually like to tell clients that from the outset. Like, if I set them up with lien treatment, I try to let them know, like, you're responsible for these bills regardless of how the case goes. But because I think your case has a lot of merit, I'm going to authorize this treatment.
Well, I think that portion is missing for a lot of, I know in my experience with some other PI firms, they will not explain, because they send them out. It's generally a mill and they're sending them to the same, the Kairos or whatever. And the problem ends up being that, like you said, if the settlement's less or then the client's like, wait a minute, we settled for the X amount of money. How come I only got this much? Well, all the treatment that you did had to be paid for. And I think that can be somewhat of a sticker shock for clients too.
Right. I usually like to explain clients everything like as it is. I'm like an open book. And then sometimes clients don't like what they have to hear, but then I remind them, like as your attorney, my job isn't to make you happy. It's to like let you know the truth, like how it is. And so I could properly advise you on how this case is going to go.
No, that makes perfect sense. Well, James, I really appreciate this. Definitely, I'm looking forward to us talking again. And like I said, I'll do me a favor, shoot me off the link for your website, and then I'll definitely post it up, and and we'll go from there.
Okay, thank you for the opportunity.